introduce our second speaker, Tim Macknay, lawyer for the Environmental Defenders Office. Born and bred in Western Australia, Tim graduated in law with honours from the University of Notre Dame in 2003 and was awarded a postgraduate diploma in environmental management from Murdoch University in 2007. While at law school, Tim received a Peace Builders Award from the Australian Government for foreign aid work undertaken in East Timor. After graduation, Tim served as an associate to the late David Malcolm AC, Chief Justice of Western Australia. Tim has worked in environmental law and policy since 2006, including work for industry and private practice, government work and pro bono work for environmental NGOs and community legal centres. He's the past president of the WA branch for the National Environmental Law Association. Before commencing at EDO, Tim had a senior legal role with the Department of Water and Environmental Regulation. So Tim will be talking about control of clearing, bush forever sites and their legal protection, and the role of the Environmental Defenders Office. And I'll see if I can get this presentation up for you.
I'd just also like to briefly acknowledge the Whadjuk Noongar people who are the traditional custodians of the land that we're on today, Boorloo, which of course in sovereignty was never ceded over this land. So the joint sovereignty that Chief Justice Quinlan was talking about is a reality, because the Whadjuk Noongar people still assert their sovereignty over this land. Thanks again, Hugh, for I think what was quite an inspiring sort of picture about how the principles in the Act can be used to advocate for greater protection of urban bushland. I think my presentation is probably going to be a bit more dry and technical and narrow, hopefully still useful though. So what I propose to do, and knowing as well that Professor Tonts is going to be talking about the EPA and its role, I propose to really talk about the clearing provisions in the Environmental Protection Act and how they apply to urban bushland, and sort of give some pointers about how to sort of try to make the most of that process, and how to try to make it do better. I also want to just talk a bit more about bush forever sites specifically, and how the clearing provisions apply to them in a very particular way, and also what can be done to improve their protection. So the clearing provisions, no doubt some of you here have probably had interaction with the clearing system and the planning system. Obviously you've all worked with the planning system to some extent, but who here has dealt with the clearing system under the Environmental Protection Act? Yeah, so quite a few of you. So there have been some changes to it quite recently that it's really useful to be aware of, because they unfortunately open new loopholes, but also are a new area of focus for advocacy. So the clearing provisions, as they're called, are in Part 5 of the Act, Division 2. They were introduced in 2004, and what they do in summary, the main provision is Section 51C of the Act, which in general provides that clearing is prohibited except where the person wishing to clear holds a clearing permit or the proposed clearing falls in an exemption. But the 2020 amendments to the Act also introduced a new clearing referral system which entered into operation this year, and under that it's another avenue in which clearing can be authorised, where the proposed clearing is referred to the CEO of the Department of Water and Environmental Regulation, and then that CEO can then make a determination about whether a permit will or won't be required for that clearing, which means that there is the potential for clearing that in the past would have required a permit to now not require a permit if the CEO decides that it doesn't need one. All right, so the clearing provisions apply to land and clearing of native vegetation across the state in general. In the urban context, certain exemptions come into play quite significantly because of the way the clearing provisions interact with the with the town planning scheme, and in particular there are certain exemptions that that mean a clearing permit isn't required. There are two categories of exemptions from the requirement for a clearing permit. The first is the category of exemptions that are set out in Schedule 6 to the Act, and then the second is the category of exemptions that are set out in the clearing regulations. So the Section 6 of the Act, there are actually two particular exemptions that are particularly relevant to the planning system because they provide that clearing permits are not required when certain kinds of planning approvals are in place. So the first main exemption is the item 6 exemption, which I've called the approved scheme exemption. And that is concerned with clearing that's done under a planning approval where the relevant planning scheme has already been assessed by the EPA and it's effectively been approved under Part 4 of the Act. And that's the actual provision itself. The case of a proposal that was made under an assessed scheme and because of Section 48I2 was not referred to the EPA in the implementation of the proposal in accordance with a subdivision approval, a development approval or a planning approval given by the responsible authority. And so in plain English terms, that means it's where the planning scheme has been previously assessed by the EPA, the proposal that involves the clearing is consistent with the planning scheme, and there is a subdivision approval or development approval for the proposal, and the clearing is consistent with the subdivision or development approval. So that's the first exemption that comes up. And the implication of these means two things. One is that it's critical to engage at the planning stage because once the approval goes through, it's much harder to stop clearing that occurs. So when there is a public input component in the planning stage, whether it's an amendment to a planning scheme, whether it's a subdivision proposal that's under consideration by the Planning Commission, or whether it's a development proposal development application that's under consideration by a local government or a joint development assessment panel, it's critical to engage at that point because once the approval goes through, it gets harder. I'm sure many of you already know that. But I don't propose to talk about engaging in the planning system because I know others are talking about that, and I wanted to focus on the Environmental Protection Act, which is the heading. Then the other exemption that's relevant in the planning context is item 9 in Schedule 6, and that concerns subdivision approvals. So again, the provision states that the exemption applies for clearing in accordance with a subdivision approval given by the responsible authority under the Planning and Development Act 2005, including clearing for the purposes of any development that is deemed by Section 157 of the Act to have been approved by the responsible authority, and clearing in any building envelope described in the approved plan or diagram. What that means in plain English, more or less, is that there's a subdivision approval. There's the section that refers to Section 157 is concerned with ancillary works to the subdivision approval that are done by government utilities. So typically when you have a subdivision approval, power has to go in, water has to go in, drainage and sewerage have to be put in, and they're all done by government authorities. And under Section 157, there's an implicit approval, the subdivision approval by the WA Planning Commission is deemed to also approve the works that are necessary to do that ancillary infrastructure work. But the important thing to remember about both these types of exemptions are that they're not the end of the story. They don't give a blanket carte blanche for clearing to occur once these approvals are done. In fact, the clearing that can be done is constrained by the terms of the approvals themselves and by these provisions. So again, if you look at the... sorry, this is the wrong one. I'll go back again. If you go back to the approved scheme exemption, so it has to be in accordance with the approval, and the proposal has to be consistent with what's approved under the scheme. So it's useful, I think, to scrutinise these approvals to determine precisely what it is that they do approve in terms of the land that can and can't be cleared, because there tends to be a presumption, as Hugh said in his presentation, developers sort of think that they have a right to clear, and there tends to be also a bit of a casual presumption by authorities too that once the approvals are in, kind of the deal is done and off you go and you do it, and we're not going to pay that much attention provided you don't do anything too egregious. But in fact, in law, the only clearing that's permitted, at least without a permit, is specifically constrained to what is authorised by these approvals. And similarly with the second, the subdivision item approval, it's actually even more specific because it talks about descriptions on the approved plan or diagram. And if you go to Section 157, which I haven't actually put out here, it also comes back to these ancillary works that are deemed to be approved are works themselves that have to be shown on the plan in order to fall within the authorisation, which means that even though it's a subdivision approval, it doesn't mean they can clear whatever they like. It actually means they can only clear what the plan, if you look at the actual plan of the subdivision approval, the parts that it's clear from the plan, it's necessary to clear. The rest in law actually requires a clearing permit. And I tend to, and I think it's useful to scrutinise these things more closely, just because it's not done enough, and there's a presumption that once these approvals are in, off you go. It's too late. You can't do anything about it. But in fact, they're more constrained than they seem to be. So that's just something to bear in mind when it comes to planning approvals and the way these exemptions work. They're not absolute exemptions. So, and any clearing that's not authorised under these exemptions, a clearing permit will still be required, or at least a referral to the EPA. So a subdivision approval itself just does not, I'm repeating myself now, but the point can't be made enough. A subdivision approval itself does not just give you carte blanche ability to clear everywhere on the subdivision approval. It's actually quite constrained, and I think it can potentially be used more to try to hold back some of the destructiveness of some of these developments. All right. So that's sort of the exemptions that are associated with the planning approvals that fall under Schedule 6 to the Act. So the other set of exemptions that can be relevant to urban bushland are exemptions that fall under the regulations. And so these exemptions in many respects are probably more, I think, less relevant to the context where you have proposed developments on bushland, and more in the context of how existing urban bushland is actually managed. Because the sorts of exemptions that fall under the regulations tend to be ones to do with ongoing management or land use. So there's a whole range of exemptions. They're in Regulation 5. There's a table of regulation exemptions. They have all sorts of things associated with pipelines and mining exploration and so on. But the ones that are potentially relevant to urban bushland are mainly fire hazard reduction, clearing, maintenance of vehicular tracks and walking tracks, and existing cleared areas around infrastructure. Those are the sorts of exemptions that will typically be used by local governments, who are usually the entities that are managing urban bushland, although sometimes you get state government instrumentalities as well. Again, these exemptions are more constrained than they're often thought to be. I haven't gone into detail here, but there are specific criteria that enliven the exemption, and there are typically limits on width, for example, for things like track maintenance. There are limits on the width that you can clear to. You can't use it to widen the track, for example. You have to maintain the track, not widen it. They're not often adhered to by local governments, but it is in fact illegal for the local government to clear in a way that's not consistent with that exemption, or it's illegal in the sense that if they don't have a clearing permit, they're committing an offence under Section 51 of the Act. So, and we do get inquiries. The EDO does get inquiries from friends groups and so on who monitor the management of bush forever sites and other areas, and we often hear that local governments just simply aren't following the rules when they carry out management of urban bushland, and that's something that, given that it's illegal and there are actually potentially legal remedies involved, can probably benefit from closer scrutiny. So I'll just talk briefly about this new provision, the clearing referral. So this was introduced in the 2020 amendments to the Environmental Protection Act, but it only entered into force, I think, on the 1st of July this year. It took them a little while for the bureaucracy to get ready for it. So what it does is, previously, all clearing that wasn't in an exemption required a permit, and so you had to put in an application and go through the application process that involved a requirement to publish the application and seek public comments, and there was also an appeals process, and still is an appeals process at the end. This process is quite different. You can just make a referral to the CEO of the Department of Water and Environmental Regulation. Then they make a determination. There isn't a public comment period. There isn't an appeal period. There is a requirement to publish the referral and to publish their decision, but that's it. But they can decide whether or not whether or not a permit is required for the clearing. So it's a kind of a new you know, and it's in the negative way of looking at it is that it's a loophole now. It's a new way that you can get authorisation to clear without going through the process of having a proper evaluation and an appeal and a public input, which you would find with a clearing permit application. It does have some limitations on it, fortunately. So there's a set of criteria that the CEO is required to consider. Whether the area is proposed to be cleared is small relative to the total remaining vegetation within the region and within the relevant ecological community. Whether there are any known or likely significant environmental values. Whether the state of scientific knowledge about the vegetation in the region is adequate, and whether the issues arising from the clearing are likely to require conditions to manage or mitigate effects on the environment. So it's useful that those criteria are there. They are still quite broad. They do give a lot of discretion, particularly I think the meaning of the word small in that context is a tricky one, because what is small, depending on how the CEO interprets that, could have a big impact on the sorts of things that on the overall scale of clearing that they'll let go through to the keeper as opposed to put into the permit system. But it does create, I think, a need for advocacy around this to try to establish community expectations about how this process will be used. The process has now started to be used. There are publications. I might just quickly see if I can. Perhaps not. I'm sorry. I was just hoping you could. Urban Bushland Council. Thanks. I just thought I'd quickly.
Where are you going?
I just wanted to say, am I running out of time, am I?
That's all right. It's always really hard work doing it while we've got an audience.
Yes. Yeah, people are waiting. Hurry up. All right, so this is the web page. There's the web address there. So this is where the new referral decisions are now published. So they are all publicly available, so you can have a look at them there. And you can see that's that's just the information. So I won't spend too much time on that. But that's where you find that information. But now that this process is occurring and it doesn't have a formal ability for community comment on these referrals, there needs to be some advocacy to the CEO setting the community's expectations about the sorts of things that we think shouldn't be allowed to go through this process and the sort of things that maybe are acceptable. Yes, if you don't mind putting it back now, that would be great. Thanks.
No pressure at all.
That looks pretty. Thank you very much. So that's the new brave new world of clearing referrals. So that's an overview of how the clearing provisions themselves currently operate. I just wanted to talk a little bit about bush forever sites and the particularly different characteristics about them. I'm not going to talk about what bush forever sites are because as the Urban Bushland Council, I have no doubt that you are very familiar with them, save as that to say that obviously they're created under policy. There's 2 volumes of the bush forever sites documentation, which are documents held by the Planning Commission, and there's also a state planning policy that Hugh included in his presentation earlier. So it's a consideration in the planning process, and bush forever sites themselves are usually some form of Crown land that's invested in a local government or sometimes a state instrumentality. There might also be some that are freehold land, but usually held by a government entity of some kind as well. So they're not conservation estate in the same way that national parks, conservation parks, and so on are. What they are, though, is environmentally sensitive areas. Now, environmentally sensitive areas are important in the context of the clearing provisions because, in particular, the exemptions under the regulations don't apply. So if you want to clear an environmentally sensitive area, you need a clearing permit. You can still get an exemption under the Schedule 6 exemptions. That means if there's a subdivision approval and your proposed clearing is consistent with all the requirements of that, that will still apply. But the other exemptions the track maintenance, the bushfire control, yes, clearing around infrastructure and so on, those exemptions are not available for bush forever sites because they're an environmentally sensitive area. And this is something that friends groups have brought to us because it doesn't seem that local governments that administer some of these bush forever sites are actually aware of that. So they go in there, they do track maintenance, they sometimes widen the tracks, they use pesticides in a fairly careless manner and so on. And in fact, they're committing an offence under section 51C of the Environmental Protection Act because even though it's a council reserve, it's a bush forever site, which means those exemptions under the regulations don't apply. So that's, I think, a current issue with the management of some bush forever sites that we're aware of, possibly many of them. I don't know for sure, but there are at least several of them where we know that is occurring, thanks to... Sorry? Well, Trig is one. Yes. But there are also some limitations to... So that, I mean, that's a benefit of having a bush forever site. It does have that additional piece of protection that they are classed as environmentally sensitive areas. Also, environmentally sensitive areas, where do they come from? They're created... The current ones are created through a notice. It used to be that a ministerial declaration under the Act created environmentally sensitive areas. In the 2020 amendments to the Act, it's now regulations, which in substance doesn't make a lot of difference, although I suppose it creates the potential that the regulations will be amended sometime soon and the environmental sensitive areas will be upgraded, which I think is important because as you can see, this is the way that bush forever sites are included in the environmentally sensitive areas, and it's a fairly qualified protection because they're not just completely environmentally sensitive areas, they're only environmentally sensitive areas to the extent that bits of them don't have a development approval over them by the West Australian Planning Commission. So how good is that protection? Well, clearly not good enough. So I think certainly one specific point for advocacy should be to amend the environmental protection, environmentally sensitive areas regulations, currently called a notice, but they will be regulations in the future, to improve that protection so that this sort of carte blanche sort of, if you can put a planning approval over the bush forever site and then it takes away some of its protection thing, should be removed, so the protection should be strengthened. That's just one particular point that I wanted to make. So I guess what can be done in general to protect bush forever sites? So as I said before, I think monitoring management activities of them is good because we do know that they're currently not really being managed in accordance with the law right now, and we think their management could improve considerably if local governments were held to the requirements of the law, and that can be done by writing to local governments and to the Department of Water and Environmental Regulation, making complaints through. There is an unlawful clearing complaints page on the DWER website. You can sort of make a formal complaint about it, but probably constructive that's like probably something you do after you've written a couple of letters to the council and they've ignored you, perhaps. As I said, strengthening the environmentally sensitive areas regulations to take away those loopholes from the protection of bush forever sites. I haven't talked about the EPA and what can be done there. I think Matthew Tonts will talk about that later. But for a few years there was the strategic assessment of the Perth and Peel regions that was being done under the federal environmental legislation. That's now gone, but there is, I think, scope for some strategic thinking about protection of urban bushland, and certainly the EPA has the power to give strategic advice on various things, which they recently did with the Brixton Street wetlands, for example, and also for the Exmouth Gulf last year. So I think exploring whether strategic advice from the EPA about conservation of urban bushland might be one path forward to assist in the process. The other thing, of course, is to advocate to strengthen the reserve status of bush forever sites, to take them from just being council reserves or pieces of Crown land that are managed by various entities and perhaps turn them or look at transferring them into formal conservation estate under the Conservation and Land Management Act so that they become conservation parks or national parks. So those are a few thoughts about what to do. I should talk a bit. I did say I'd talk a bit about the role of the EDO as well. How much time have I got? Christine?
1 minute.
1 minute. So that's right. I was only going to talk very brief. So the EDO, for those of you who aren't aware of us, we're a non-profit public interest environmental law centre. Our strategic goal is a world where nature thrives. We're non-government. We are funded by philanthropic donations and donations from the public and a bit of government money. 2 years ago we merged and became a national organisation. I used to be the head of a small EDO of WA, and Hugh used to be on the management committee of that. Now I just run a WA part of a national organisation, which has in many ways strengthened EDO's ability to do big picture strategic litigation. We're doing a lot of, you might have seen in the media, the stuff we're doing against the fossil fuel industry around the country. But we're still working on how we work as a national organisation. So in the local space, we can provide advice. Our capacity to assist with litigation is limited because litigation is very resource intensive, and usually we can look at if there's a piece of litigation that has a lot of strategic significance. If you can achieve really big results from one piece of litigation, that's usually something that EDO can look at. But we don't really have the capacity to help with litigation to protect small areas individually. But we can certainly provide advice and assistance in other ways in the task of trying to protect the urban bushland that's so important to us all. So thanks for your time.